Okay, so we are back and we'll go through our casebook hypos starting on page 252, and there are 9 of them. So in number 1, our hypo is Claire Schimberg sues X department store for damages for injuries that she received in slipping on the department store's floor. Claire claims she slipped and fell because the floor was highly waxed and polished and unduly slippery as a result. The department store offers into evidence a report prepared by B, the store manager, and B is no longer in the store's employ and could not be found to testify. So the store's evidence establishes that the store manager's report was prepared the day after the accident and that the store's manager customarily makes a report after an accident. The manager's report states that he arrived at the scene a few minutes after Claire fell and while Claire was still on the floor, and that the manager examined the floor and it was not highly waxed or polished, but had a dull finish and was not slippery. Claire objects to the report as hearsay, and our question is, should the objection be sustained? So our answer is, under either federal or California law, there's a strong argument for sustaining this objection. So the report is of an accident, and it's made by the store manager to determine the cause of the accident and the effects. So we can imagine this was made with an idea of possible litigation. You know, the store manager works for this store, and they know if someone was hurt based on something that was negligent or, something that they might have done, they want to paint themselves in the best light, which means we're not getting that trustworthiness piece that comes with the business record exception. If they're making this report specifically to cover their butts in case this woman sues, you can see how it might not just be trustworthy, accurate information that was reported. The store manager is someone who worked for this company, not some outside third party making a report. So when we're looking at that fifth factor of trustworthiness, the things that we want to look at are the sources of information, the method of preparation, who's making this report, and where are they getting their information from. So again, a manager is motivated to report that the environment at work is safe because he's the one supervising it. Okay, number 2. So in this hypo, we have X is prosecuted for robbery. X's defense is an alibi. X testifies that he was in a faraway city and that he had just registered at a motel at the time the robbery occurred. X calls a clerk from the motel who at trial identifies a registration card that was prepared by another clerk that shows that X, someone with X's name at least, with X's address, registered at the motel at the time of the robbery. The registration card doesn't have X's signature on it, and the clerk testifies that the motel clerks frequently fill out the registration cards with information that the guests give them, but don't require any further identification or signatures. X wants to offer the registration card into evidence, and the prosecution makes a hearsay objection. So our question is, what is the result? So under both federal and California law, the objection should be sustained. There's some conflicting case law on this subject, so it's not super clear. You could make an argument either way. But for the most part, courts see this as not enough, again, there's not enough indicators that the information provided was truthful or accurate. The person giving the information is the guest, who is not an employee of the business and doesn't have a duty to provide true information. So you could imagine a guest could come and give a fake name, and without checking ID, asking for signatures, without doing anything more, There's nothing in just asking a guest their name that's specifically very trustworthy. So just like in the last typo, we are kind of missing that fifth factor of trustworthiness. So there have been at least a few courts that have found just the evidence of the registration card itself is not admissible to show that the defendant was in fact at the motel. But that if there was more, it could maybe be admissible to show that at least someone using the defendant's name was present. That might not be relevant, but it's at least something that you could show. You could show that someone was at this motel using the defendant's name. And then if you had more evidence to prove that he was there, then maybe that piece, along with your other evidence combined, would become relevant. So again, if you had something verifying the registration, showing an ID, having a signature, any other additional information that you can give would make that record more reliable. It doesn't guarantee that it would be admissible, but it's at least more likely than the fact pattern we have here. Okay, number 3. So in hypo 3, we have A suing X for fire damage to A's house. So A had hired X, who is a general contractor, to remodel A's kitchen. And just before the work was complete, a fire started in the kitchen and caused damage. So A claims that the fire resulted from X's negligence in leaving open a can of highly flammable cabinet stain that was too close to the pilot of the water heater. In the contractor's defense is that the fire was the result of arson. So after laying a proper foundation, the contractor offers into evidence a report by the captain of the city's fire department. So the captain's report stated that under his investigation of the fire, he also includes an inspection of the premises, conversations with A's neighbors, and that based on that investigation, he concluded that the fire was potentially arson. A objects to the report as hearsay. So our question is A's objection proper? So this is another example of a business record probably not applying. So we have, again, an issue with the information in our report being made by someone who does not have a duty to make an accurate report. Remember, when we're dealing with a business record, we think that a business record is more reliable than just normal hearsay because businesses will want to record accurate information so that their business can be run well. So if we have a fire captain giving his, reports on what he's seeing with his own experience and expertise, that would be one thing. But we now have statements by A's neighbors included in the report. And A's neighbors are not part of this business or public office and don't have that duty to provide accurate information. However, we might be able to qualify this under the public records exception. So in our report, our fire captain concludes that the fire was arson. And this is similar to one of your casebook readings, Beech Aircraft versus Rainey, where we had a Navy officer concluding that an accident was caused by pilot error. It was caused by an accident. And we, in that case, found it was admissible under 803A, which is our public records exception. So just like that here, we could try and qualify this report not under a business record exception, but under a public records exception. So when we're dealing with investigations like this, remember, if the officer was deemed to be a law enforcement for some reason, this would still be okay because we're dealing with a civil case, not a criminal case. So not being excluded as a criminal police report, we're dealing with a civil case, and so that's still okay. Okay, number 4. We have P suing D for damages for injuries suffered in an automobile accident. So P does not call a doctor to testify, but offers into evidence the doctor's report. The foundation is established that the doctor's report is the only record kept by him in the ordinary course of business. The record recites that the doctor examined P on a certain date, had x-rays taken, and diagnosed a fracture of the femur. In a separate paragraph of the doctor's report, he also gives a prognosis, and it states that in the doctor's opinion, P will suffer permanent residuals of a limitation of motion. The defendant makes a hearsay objection, and our question is, how should the court rule? So under federal law, so we'll look at both federal law and California law. Under the federal business record exception, this specifically includes opinions and diagnoses. So within hospital records, both the diagnosis itself and the opinions or prognosis that the doctor writes in is also included. Before we had this federal rule, there were federal cases that excluded these things. But since then, we now have the FREs, we have the federal rules, and those are now controlling, and so this would be okay. There is a 403 argument, which is our balancing test, an argument that with these opinions included, it could be too prejudicial to the defendant or maybe too confusing to a jury. They're not, medical doctors. You want the reports to say, this is what my patient looked like. This is the, problems he had, and this is what I treated him for. Once you get beyond that and getting into opinions on how the patient will be doing in the future, it might confuse a jury. But again, if we're just looking at the business record exception, this would be fine. Under the California rules, this is a little bit different. So the part of the record that's talking about the diagnosis, that could be admitted under our business record exception. But the portion giving the prognosis or the opinion about what will happen to the patient afterwards would be excluded, again, because it's arguably like an opinion. And in our California rules, it specifies that what can be included is just the act, condition, or event. So things that are talking about the accident itself, the x-rays done, the broken femur, but not so much how he might be limited in the future.